Good morning to all of you. Welcome to my Torts class. Friends, we are now discussing the important topic of negligence in this Torts class. So basically, whenever you are supposed to do any particular work, you should be careful. You should be diligent. You should take all precautions whether it is correctly being done or not. So that means you should not be negligent. Negligence means lack of care, carelessness, recklessness. So negligence is the opposite of diligence. So it is nothing but breach of duty of care. If there is breach of duty of care, if something happens, the result is you are going to get an injury, that is legal injury, for which you are liable to get compensation. Negligence normally will be taken as a case of tort, and you can file a case of the called criminal case also. But normally, since we are dealing with the topic of torts, so let us confine to the tortious negligence, right? So according to John Salman, so he said negligence is culpable carelessness. Culpable means punishable. Culpable homicide not amounting to murder. When we are discussing section 299, then you will be knowing what is culpable homicide. Note 9 of the ABC, right? Negligence is the culpable carelessness. It consists in the mental attitude of the undue influence with respect to one's conduct and its consequences. So that means it is a mental state of element. This is a subjective theory by John Salman. But Pollock, he said negligence is opposite to diligence. So that means, of course, we can't describe diligence as a state of mind. Suppose, best example is a person in a drunken state, he was driving the vehicle and he has hit the pedestrians or the person sleeping on the pavement dwellers. And at the time of giving punishment, the judge should not think that his drunken state, he was afraid, all this. Since he has committed mistake, since he is negligent, he has to be punished. That's all. So state of mind is not an important thing. Of course, already I told you in the law of torts, so you don't want any mens rea in the act. Even though there is no intention, there is no motive, definitely we can file a case of tort. Right? Now we will discuss what are the essentials of the negligence. Number one, duty of care. That should be breached. Result is some damage to the other person. Right? Duty of care to the plaintiff. Suppose we don't have the duty, definitely will result in negligence. So very famous case law we are going to discuss. I am sure you will get it in the examination. Donoghue versus Stevenson, 1932. Donoghue, she is a young girl or lady. So Donoghue and her boyfriend, they went to a bar and restaurant. Of course, it happened in Scotland. So they went for enjoying the day, and the boy ordered for a ginger beer. And this woman took it, and it was supplied in an opaque bottle, not transparent bottle, please remember. It was supplied in an opaque bottle. మనకి ఎక్కువ హనీ కలర్లో ఉంటాయి కదా, తేనె రంగులో, అది లోపల ఏందో మనకు అర్థం కాదు. Right, so which was supplied, and she gulped the first gulp, and secondly she was pouring it in the tumbler. At that time she saw the remnants of the dead body of a snail. నత్త యొక్క చనిపోయింది, నత్త చచ్చిపడిపోయింది, దాంట్లో భాగాలు కనపడింది. Then she started vomiting. She was taken to the hospital. She suffered from gastroenteritis. She was there in the hospital for over 4 days. After discharge, she filed a case against the manufacturer, that is Mr. Stevenson. Mr. Stevenson was the manufacturer of the so-called ginger and so many other products. Now she filed a case of tort against him for negligence because the bottle contained the dead remains of a snail, which should not have been done, is it not? మనకు కూడా చూసే ఉంటాం, గోల్డ్ స్పాట్ పాతకాలంలో థమ్స్ అప్ వీటిల్లో వస్తూ ఉంటాయి చిన్న చిన్న పీలికలు, సన్నట్టు. ఒకసారి స్ట్రా చిన్నది కూడా వచ్చింది మనకి. అలాగే కప్పలు కూడా వచ్చినాయి, కొంతమంది అనేవారు చచ్చిపోయిన కప్ప ఉంటుంది. సో అలాగా వచ్చింది. నౌ షీ ఫైల్డ్ ఎ కేస్ ఆఫ్ negligence, right? So now important points for discussion. So three principles, two important at least. Mr. Stevenson, he said There is no privity of contact between Mrs. Donoghue and myself. Second, she is not a neighbor to me. I don't need any pay. I don't need to pay any compensation to her, because the chain of events disclose that he is the producer or he is the manufacturer. From him, the distributor will take the so-called glasses, property. From there, they will go to the retailer. Then only they will go to the consumer. So there is a contract between the distributor and the manufacturer, not with the consumer. So there is no privity of contract. Then the court said, no. Once you manufacture, you got the responsibility till the product reaches the last place. Suppose you may get it out. Suppose మధ్యలో డిస్ట్రిబ్యూటర్ ఏదన్నా కలిపితే ఆ పరిస్థితి ఏమిటి? ఇక్కడ చైన్ ఆఫ్ ఈవెంట్స్ చూస్తే డే బై డే వరుసగా వాళ్ళు మిస్ చేయడానికి టైం లేకుండానే ఇట్ హ్యాస్ రీచ్ ద కన్జ్యూమర్. సెకండ్ పాయింట్, నైబర్ ఎందుకంటే యూ డిడ్ నాట్ ఆర్డర్ ద జింజర్ బేర్, ఆర్డర్ బై హోమ్ హర్ బాయ్ ఫ్రెండ్. సో హీ డిడ్ నాట్ సఫర్, ఈజ్ ఓకే. దెన్ హౌ కెన్ యూ కంప్లైన్ ద కేస్? నీకు సంబంధం ఏంటి? నువ్వు కొనలేదు కదా నా దగ్గర. అనదర్ పాయింట్. సో దట్ నైబర్ ప్రిన్సిపల్ వాజ్ ఎక్స్టెండెడ్ అప్ టు ద కన్జ్యూమర్. అయ్యా, ఎవరైతే కొన్నారో వాళ్ళు కాదు, ఎవరైతే కన్జ్యూమ్ చేశారో వాళ్ళు కూడా నైబర్స్ కిందే వస్తారు. అల్టిమేట్లీ కోర్ట్ సెడ్ every manufacturer has got a duty of care towards the consumer up to the last point. He must take reasonable care to avoid act or omission which he can reasonably foresee. This is a test of reasonableness. I will tell you later. Would be likely to injure your neighbor. So failure to ensure the product's safety is leading to negligence. So definitely it is allowed as a negligence case. So this case is otherwise called as snail in the bottle case. So this happened on 26/8/1928, but still it remains as a landmark judgment, right? So this is the case of straight case of negligence where Lord Atkin, he ordered damages to the victim. Right, very good case. Please remember, and definitely you will get a question on this particular topic. Of course, not in this case. Negligence is an important topic we have to discuss. Right. With this, I am concluding. Thank you very much.